Hello, everyone. Welcome to the Stanford Cyber Policy Center's Tuesday lunch series. We have a smaller crowd in the room today because Stanford students have the day off to go vote, which is excellent, but we have a pretty big group on Zoom. Here for today's speaker, Dr. Aleksandra Kuczerawy. Dr. Kuczerawy is one of the most promising young academics in working on European regulation of platforms and the speech that they carry. With a focus both on statutory details and the ways that they affect the fundamental rights of internet users. She is going to talk to us today about the new Digital Services Act and the sea change that it will create for the regulation of internet platforms. Aleksandra?
Thank you so much for the nice introduction and for having me here. And thank you for thank you to the Cyber Policy Center for actually having me and hosting me for the last few months. That was absolutely great. So I would like to share some news with you from the EU about this new regulation, the DSA. And just to be very clear, that does not stand for Democratic Socialist of America, as Google tried to convince me the first 2 weeks of being here. So the DSA, the Digital Services Act, is this new legislation coming from the EU, which is supposed to change or potentially change how the online environment works and how platforms operate. Okay, but before I get into details, let me just make a little change here. Okay, so before I get into details, I wanted to show you that this is not the only piece of legislation that you may be interested in coming from the EU that's attempting to regulate online platforms and other digital services, either directly or indirectly. So we have I broke something. Sorry. This is not moving. Okay. Thanks. We have some older pieces of legislation, mainly the Audiovisual Media Services Directive, that is basically requiring online video sharing platforms to protect minors from harmful content, but also all the other users from incitement to violence. We have Copyright and Digital Single Market Directive, which is basically mandating the use of upload filters to make sure that users don't upload copyrighted material. And then we have terrorist content regulation, which requires platform to remove terrorist content upon notification within 24 hours. We also have a sister act to the Digital Services Act, the Digital Markets Act, which is it entered into force just a few weeks ago, and it also regulates online platforms, but instead of focusing on online harms, it focuses on promoting competition and put end to unfair practices by what they call online gatekeepers. And then we have a whole set of Why do I keep breaking? Okay. Sorry. So then we have a whole set of new types of proposals that are at different stages of maturity. And I will not talk about all of them, but here you have an overview of them. And I think the CSAM regulation is the one that might be very interesting, as it will require not only online platforms, but also private communication tools to monitor content of their users to detect either images with child sexual abuse material, but also to scan text and conversation to detect potential grooming situation. And then on top of that, we have a bunch of self-regulatory initiatives in the forms of code of conduct, which are not mandatory for platforms to join, but they're strongly encouraged to do that. And then to create their own rules that they would follow to combat either, in this case, illegal hate speech or disinformation online. Some basics on the DSA. So here you have a full name. It was published in the official online journal of the EU on the 19th of October, so very recently. And just a warning, if you're actually interested in what's in there, make sure that you're looking at the final version, because there has been so many of them, and even in the final stages, changing some wording, changing the numbers of articles. So if you're going to look at, make sure that you have the right one. The proposal, initial proposal, was published in the end of 2020, and then it went through this long process of negotiations and approvals. It will enter into force next week, actually, but it will start applying only in February 2024. So there's this period when platforms that will be actually covered by it have time to prepare what's coming. Although there are some provisions there specifically addressing very large online platforms that will be applied even earlier. It updates the old e-commerce directive, and the big difference here that now it's in a regulation. So the difference here that the directive had to be transposed into national legislation of each member state, and that resulted in some differences. But the regulation, what we have now, will be directly applied. So basically, it will be the same law in every European member state. It's a long piece of legislation. It has 93 articles, which are where the binding rules are. And then it also has 156 recitals, which are not binding, but they provide explanation and interpretation. And I'm saying it because here, like, sometimes I see people mixing it up and referring to recitals as the binding rules. So make sure that you get that. The ambition of the DSA is to defend and promote European values in the online space. And it has specifically two main goals. Okay. One is to create a safer digital space. And that means that it focuses a lot on combating illegal content. It codifies procedure for removal and blocking of illegal content. It mandates creation of protocols for crisis situations. So that could be, for example, blocking propaganda coming during a war in a neighboring country, or potentially, organization of a violent insurrection. It also supports platforms' own action to act against content that is not necessarily illegal, but violating their own terms and conditions. And it encourages them to sign up or take initiatives of self-regulatory nature. It also wants to ensure better protection of fundamental rights online. Okay. Including, and it actually has a broad variety of rights that it focuses on, right? So right to freedom of expression and access to information, but then freedom of thought, right to assembly, right to privacy, right to data protection, protection of minors, and also right to effective remedy. And to achieve this, the DSA introduces a number of protective measures. for users to have more balance and to have more protection of their rights. So, for example, rules on how to file a notice when content is about to be removed, or that they have to be notified when somebody removes when the platform removes their content. Also, they can challenge the decision, content moderation decision by a platform. It also prohibits certain types of advertising. Okay. And then you might wonder why there was a need to update the old rules. So the directive Okay, so the directive, as I said, is an old piece of legislation. It's from 2000. So obviously a lot has changed since then in terms of how platforms look like and what kind of services they offer. And since about 2010, the Commission was in the process of reviewing these old rules. There was a bunch of public consultations where different stakeholders would clarify what kind of concerns or problems they have with application. And some of these concerns kept repeating constantly. So, for example, inconsistent application across the EU. Terms in the directive, for example, expeditious removal or actual knowledge, were interpreted and understood differently in different countries and by different stakeholders. There were a lot of complaints about illegal content that stays online even after a notification. But at the same time, a lot of complaints about legal content that was being removed. Basically, a lot of commentators, academics, civil society organizations pointing out that the approach of the directive is basically encouraging restrictions on freedom of expression. And here, to show you some examples that were widely discussed in the EU during that period. So we had removals of content that was discussing relevant but controversial societal issues, content coming from accounts in different languages that were just automatically assumed to be all bots. Also historically relevant content, obviously classical political speech, and finally content documenting human rights abuses from around the world. Okay, and then during the review, we had a bunch of other events or scandals that kind of strengthened the resolve of the EU policymakers to put some limits on how platforms behave, especially the very large platforms. So obviously we had the Cambridge Analytica scandal showing how political ads can impact electoral decisions. Also Facebook role in the Rohingya genocide, COVID disinformation, whether about the causes, the cures or vaccination. Then we had the Facebook files, for example, showing how Instagram might actually not be good for the mental well-being of teenagers. And then more recently, the Russian invasion in Ukraine and the attempts to stop Russian propaganda. So all these events happening during the discussion on the DSA provided extra push for the EU to act. So what is new in the DSA? So first of all, the DSA maintains the liability exemptions for online intermediaries that were present already in the e-commerce directive. It immunizes infrastructure layer services, such as internet access providers, but also application layer services, such as hosting providers, from liability for third-party content. But this immunity has been, back then, and still is, based on some conditions. So the main condition is lack of knowledge about illegal character of hosted content. And when obtaining this knowledge, for example, through a notification, removal or blocking access to such content. So a bit like notice and takedown under the DMCA here in the US, but basically covering any type of content, not just copyrighted material. The novelty of the DSA is that it codifies notice and action mechanisms and provides detailed procedures for handling different actions against content. So not only removal and blocking, but also suspension and termination of monetization abilities, termination or suspension of provision of the service or of the account. And that's why it's calling it, it's not notice and takedown but notice and action. The DSA also regulated how orders coming from authorities ordering platforms to remove content should look like and what should be the content of such orders. The DSA prohibits imposing general monitoring obligations, meaning that service providers don't have to actively look for illegal content on their platform. They only have to act once they obtain knowledge. So for example, through a notice, but specific monitoring obligations are permitted. And that may be based on a court order with injunction saying you should prevent the same type of infringement in the future. But also it's getting broader and broader. So for example, under the recent case of the Court of Justice saying not only the same type of content, but also equivalent type of content. So this prohibition of monitoring is getting a little bit, blurry, let's say. Also some specific legislations like the copyright directive, which mandates upload filters, is putting, let's say, a bit of a question mark here in terms of, do we still have the prohibition of general monitoring obligation? New element is an explicit obligation for hosting services to inform law enforcement if they have a suspicion of criminal offense. And that involves offenses with threat to life or safety of persons. And here the reason for that was that thinking about the most serious criminal offenses, for example, child sexual abuse, that removing that material from the platform does not actually solve the real problem that there is a child somewhere that is or has been abused. So there should be other actions. And for that to happen, platforms have to notify law enforcement. Another thing that both the directive and DSA have in common is that they don't actually have any rules saying what is illegal. So what content is illegal. That is left to the EU countries to decide because their criminal codes are not harmonized. So there are differences, different laws across the EU saying what kind of content is defamatory content or what is considered hate speech in different countries. Some countries prohibit denial of Holocaust. Some countries prohibit insulting of religious feelings. Other countries also have very strict rules on insulting heads of states. Other example here is information about access to abortion. In some countries, perfectly legal and fine. In other countries, prohibited. So that has not changed, and each country decides on its own what is actually illegal content and what are limits of free speech. Here are some other novelties of the DSA, and I will not discuss all of them, but just to give you a general idea. With regard to terms and conditions, there's basically no obligation to moderate content. But if any kind of service that is covered by DSA does that, then they have to clarify in their terms and conditions if they do it, how they do it, and also if they're using any automation for that. For recommender systems, online platforms operating any kind of recommender system should clearly explain on what basis or what parameters are used in the recommender system, and also how to modify them. There are also special provision directly for very large platforms. If they have recommender system, they have to offer at least one option that is not based on profiling, although this option does not have to be a default one. With regard to transparency, there are multiple provisions on transparency in the DSA with different number of elements and basically obligations to report growing with the type of service and size of the service. But there are also obligations for national regulators, obligations for providers of the out-of-court dispute settlement mechanisms. And all these obligations there are to basically keep monitoring how is the implementation going and whether there are any changes necessary to the process along the way. For advertising, online platforms are obliged to label advertisements and explain who paid for them. Also, why this particular user see this particular advertisement. Targeted or personalized advertising is not banned as such, but there is a prohibition to advertise to minors based on profiling, and also advertisement to anyone that is based on profiling built on the basis of sensitive categories of personal data, right? So that would be personal data related to racial or ethnic origin or religious beliefs, or sex life or health conditions, but also membership in union, for example. With regard to access to data, large platforms must provide access to data to vetted researchers, and those are approved by the national digital service coordinators. And that should be access to data for specific research purpose. To analyze, to research systemic risks that big platforms might be encountering, and also what is the effect and impact of the mitigation measures that they are taking. And I'll say a little more about these three elements. So one of the biggest novelties of the DSA is the introduction of the layers of due diligence obligations concerning design, operation, and operation of services. And in this context, the DSA talks about responsibility, which increases with the size of the service and its societal impact. And it's actually not related to liability for third-party content. So even if platform is not liable, it might still be accountable for violating the obligations of the due diligence obligations. So some services are only subject to the universal layer of obligations, while other services are subject to all four layers, as you can see. So we have universal obligations for all services that could benefit from liability exemptions. Then basic obligations for all hosting services, irrespective of their size. And then we have advanced obligations for online platforms with a special set of obligations for online trading platforms. And then finally, special obligations for very large online platforms and also very large search engines. And here, actually, it's not even so much the size that matters, but the reach of the platform. And it has to be at least 10% of the population of the EU. So at least 45 million monthly average active users, which is actually not the same as registered users. So I think they still have to figure out exactly how they're gonna calculate that and assess that. But that would be basically any user that is exposed to service. So if you just go and consult something without being a user, a registered user, that would still count. And the goal of these obligations is to balance the liability exemptions with some societal responsibilities as to trust and safety and fairness of these services. They relate more to the process rather than to the substance. So they regulate the general design of the service and their content moderation practices, advertising, transparency, or sharing of information. And here you have an overview that was made by the Commission, but I think it's actually from the earlier stages. And if you want to see the very detailed, there is a map made by Professor Daphne Keller, where she has all these obligations per platform, per type of service. So take a look in there. The very large online platforms and very large search engines are the most regulated of the services. With the universal, so they have all the universal obligations and additional obligations, including extensive risk mitigation responsibilities that are subject to independent auditing. Okay, then what's the systemic risk? The layered system of obligations includes special obligations for the very large platforms, again, with regard to systemic risks. And VLOPs, which is a name that I think we're still trying to get used to, they must identify, analyze and assess systemic risks that are stemming from design and functioning and the use of their services. And that is in the 4 main categories. So with regard to illegal content that might be appearing on their platforms, negative effects that their services or the use of their services may have on fundamental rights, and that is actually a broad scope, all fundamental rights, but also on specifically described protected issues. So that could be civic discourse, an electoral process, gender-based violence, or public health and minors. And finally, also with regard to serious negative consequences for both physical and mental well-being. So they have to carry the self-assessment about the potential risk or the risks that they're encountering once a year. And based on these outcomes of this assessment, they have to propose certain mitigation measures, how they're gonna basically deal with these risks. And typically that would mean redesign of their amplification or moderation processes, or how the recommender system works, their advertising rules, or, for example, giving more protection to certain vulnerable groups. They also must consider their actions in the local context, and that is having in mind that the amount of resources they invest in some of these issues in different parts of the world are not the same. So they should be taking that into account, also including different languages that they're covering. The risk reports should be submitted on their own expenses to independent auditors, who then should assess whether they're actually compliant with all the due diligence obligations. If the audit is not positive, the VLOPs must consider recommendations by the auditors, or if not, they have to propose alternatives. And the mitigation measures and the reports and the recommendations are then all submitted to the European Commission, and then they will be made public, although in a redacted version. VLOPs should also prepare voluntary crisis protocols for extraordinary circumstances that put serious threat to public security or public health. And the DSA grants the European Commission also a power to ask VLOPs to take certain specific measures when such crises are arising. Some more specific rules on content moderation, and now it's for all the hosting services, including online platforms. So providers of hosting services must create this easy to access and user-friendly mechanism to allow anyone to notify them about what they think is illegal content on the platform. And then the notice is reviewed by the platform, which decides whether to actually remove content or block access or maybe ignore it. The mechanism should be created in a way that allows submission of notices that are sufficiently precise and adequately substantiated, which is a wording coming from one of the judgments of the European Court of Justice. The DSA describes the elements that are necessary for a valid notice, and that means explanation of the reasons, why this person thinks this is illegal content, exact electronic location, but also name and email address of the notifying person, although there are some exceptions here, especially when the notification refers to child sexual abuse. It also should have a statement confirming belief that the information in the notice is accurate. And this is one type of mitigation measure to ensure that this notification system is not misused. Such notice leads to knowledge or awareness of the platform if the content, the indicated content, is manifestly illegal. So that means that a diligent provider of hosting service can identify the illegality without extensive legal examination. Decisions about restrictions should be what they call non-arbitrary, non-discriminatory, and proportionate, and on the basis of uniform and clear rules. And they should also be timely. And there's actually no indication what that means. So it doesn't have strict time limits like the terrorist content regulation, for example. But the severity and the potential threat to life or safety should be taken into account when platforms make a decision to act. If the notifier is known to the platform should send a confirmation of receipt and also inform them of the decision that was taken and inform them also about redress mechanisms available. Other interesting thing, the DSA provides that notifications coming from trusted flaggers, which are trusted parties that are approved on national level, but by digital service coordinators, should have a priority. What else? So providers of hosting services must provide clear and a specific statement of reasons to any affected users after any action was taken with regard to their content. So this obligation refers to actions that are based on illegality of content, but also content that was taken down because of it was violating platform's terms and conditions. It covers actions such as removal of content moderation, disabling access, demoting, suspension or termination of monetary payments, or provision of the service, suspension or termination of the provision of the service or the account. This statement must include certain information. So what type of action was taken, what was its territorial scope and duration, also why it was taken, so the reasons, and if automated means were used to either find this content or to take this decision. And again, information about available redress. And this is another novelty of the DSA, the detailed provisions on remedies in case content was removed by mistake. So the DSA offers 3 different redress routes that can be used in sequence, but also separately of each other. So there are internal complaint handling system, like the internal appeal at the platform level, out-of-court dispute settlements, but also judicial redress. So anyone could start with using the internal complaint, and then if no favorable decision is reached, then they could go to the out-of-court dispute settlement or basically to court. But they can also just start with the out-of-court dispute settlement immediately, although probably that would not be likely because the first one is free, while the other, with the other ones, there will be some costs. The providers of online platforms should create this internal appeal mechanism, and that should be available for at least 6 months from the moment the decision against content is taken. And that refers both to decisions when content was removed or other action was taken, but also when a notice was ignored and the content is still there. So you could also appeal that. And that refers again to content that was considered illegal or incompatible with terms and conditions. It should, okay, so platforms should handle complaints in a timely, non-discriminatory, so the same wording, the diligent, non-arbitrary manner. And there's not really a further indication what exactly does that mean. Do the rules have to be applied exactly the same, regardless of who the user is? I guess we'll see about that. The crucial element of this provision is that the platform should actually reverse their decision and put content back online or whatever other action was taken if the complaint contains sufficient grounds to justify the reversal. If the appeal is not successful, then they should be informed about the other options, so out-of-court dispute settlement, through which they can file again a complaint. And here usually there would be a fee, although platforms actually cover most of the costs for that. Complainants will be able to choose which body they want to choose from the list of certified bodies at the national level by digital service coordinators. Okay. And both parties should engage in good faith with the selected body in an attempt to find a solution. But platforms can actually refuse to engage if the dispute has already been resolved and all the bases and grounds are the same. And one of the most interesting part here is that the decisions of these out-of-court dispute settlement bodies are not binding. And then what happens next, I guess we'll see whether people will actually go to court or stop it at that moment, and what happens if platforms basically keep ignoring orders of the bodies. Actually, I have one more slide on enforcement, but I think this is very detailed. So just to give you very general idea, there will be national digital service coordinators in each country, although there might be more competent regulators dealing with different elements that DSA is trying to address, but then one digital service that coordinates the actions of all these competent authorities. And these coordinators have very broad competences. They can start investigations against the platform. They can also issue fines if they discover there is infringement of the obligations in the regulation. All these coordinators from all the EU countries will then form a board of digital service coordinators, which is more of an advisory body issuing opinions and helping both the coordinators, but also the Commission in enforcement of the rules. And I think one interesting element here to add is that the unique role of the European Commission, which has exclusive enforcement powers with regard to very large online platforms and very large search engines. And that is quite special and basically resulting from enforcement issues with GDPR and how, the great rules on paper might not be working in practice if there is no power to enforce it. That's it. I hope this was not too chaotic for you. If you're interested in to read more about DSA, there is a great series that's actually been, it started last week, I think, with number of pieces by great academics and thinkers from around the world on different aspects. Look at the DSA Observatory and read more about the DSA. Thank you so much. Break or something. Is that okay now? Yeah, sorry about the technical problems.
Oh, it sounded very frustrating. All right, thank you so much. That was really useful and informative. And I have a whole list of questions here, but I think we also have questions coming in over the chat or the Q&A function in Zoom. So I will be getting those on my phone here as well. So maybe I'll start with something very sort of newsworthy this week about Elon Musk and Twitter. If Mr. Musk did follow through on one of his announced plans by having a platform that doesn't have any censorship, or carries out all the speech that's legal or all the speech, could he do that in Europe now? What would that look like?
In terms of his announcements, I'm a little bit confused on what's the latest stage, but indeed, there was a moment at the very beginning when he was saying there will be no moderation and total free speech, and I think there was even some EU officials directly addressing him that, well, no, you still fall under the DSA and will have to comply with these rules. In terms of moderation, I don't think that not removing illegal content would be an option, right? Just to keep that immunity from liability for third-party content, that would have to happen. And again, there are so many different rules in different countries, what is illegal, that there would be already definitely moderation necessary there. In terms of everything else, so not illegal content, I suppose there could be an attempt to allow that, although I don't think any platform really is willing to do that. And I think even now he's already moderating content that is not actually illegal. But apart from that, that would not really let him off the hook in terms of all these due diligence obligations, which then have nothing to do, or they're separate from the liability for third-party content. So if there is any moderation, and there is moderation now happening, it would have to be explained in terms and conditions why and how it's done, and if automated means are used. And if anybody's content was removed or blocked or account suspended, they would have to be notified with the exact reasons why, on what basis, and why. And there would also have to be the remedies available, so the appeal system and whatever, and the other two remedies. So in theory, partially he could try that. I don't think that would be a reasonable choice. And indeed, the fines for not complying with the due diligence obligations are quite high. It can be up to 6% of the annual revenue from the previous year. So it's not insignificant. Whether Twitter will remain a VLOP, that will also have to be seen, since people seem to be leaving. So the level of the obligations that he might be following might also change in this aspect. But definitely, we'll see more of that.
I'm sure we will. One of the other blog posts in the Verfassungsblog blog series that you mentioned, and which both of us contributed to, talked about the change from under the old law, being one of the immunized intermediaries, like a host or a caching provider, was all upside. You got an immunity. And now it's a real mix of the upside of the immunity and then a whole bunch of obligations that come with being in that category. Another thing that I was thinking about as you talked about, what it would mean to only take down the illegal content in order to avoid liability, he would have to hire an army of lawyers in Europe to tell him what is illegal on a country by country basis because of the variations you were talking about.
Right, but then there's also here a difference. If there's an order coming from whether judicial or administrative authority, that is basically presumed that creates actual knowledge. You don't have to analyze that, just take it down. Whether you might have a different opinion on that, that's irrelevant. When it comes to notices coming from other users or not non-user as well, then indeed, only when it's manifestly legal. But of course, there's a lot of notifications where it's really hard to say, and even courts might have different opinions on whether something is actually legal or not. So there's definitely a need to have some help in terms of legal interpretations and with regard to different rules in different countries.
It's sort of a good full employment act for lawyers in the internet space. Since we're talking about territorial difference, that leads well to one of the questions that's come in from Zoom, which is about, I think, what lawyers would call jurisdiction questions. So the internet is global. Can't platforms just avoid this burdensome regulation by operating from outside the European Union?
If they direct their services to the EU citizens, then basically no. That would be the short answer, even if they're not established in Europe, but they have users there and the services are targeting EU users, that's enough to already fall under the scope of the DSA. Even if they don't have an establishment in the EU, they should still have a legal representative in one of the EU countries, and then they would be basically, subject to the decisions of or actions of the digital service coordinator from that country. But if they don't have a legal representative, then basically all the digital services coordinators from each EU country could take action. So I don't think that would be a smart move not to have a legal representative. But yeah, basically, if you have users in the EU, so it's more like the consumer law approach, where your users are based, not when your service is established.
Right, and I suppose if you wanted to really go rogue and just not comply with the EU law, you wouldn't be able to have ad sales offices and make money in the EU, which is a high priority for platforms, and eventually national ISPs might just block you.
Exactly.
So I've got another question here that is about the sort of stated goals of the VLOP protections. This is from your slide 13, the sort of civic discourse, electoral process, public security, and so forth. And what these mean and how they should shape our expectations under this law, which I think also relates to work that you've done about how fundamental rights and sort of the background rights of internet users shape the interpretation of internet law in the EU generally. Can you speak to that a little?
So I think in terms of the areas that the systemic risk where platforms have to do the assessment, that basically shows like, the most recent, the illegal content was always there, but the other, the civic discourse and the well-being, physical and mental well-being of the users. It's kind of reflecting the different events that we've seen in the recent years. They're supposed to do this risk assessment, not just address risks that are already happening or has happened, but what could possibly still come, which sometimes I imagine it's difficult to predict all different ways people can be unpleasant to each other. The interesting here is that, there are certain, there's impact assessments, fundamental rights impact assessments that are done not only under DSA, but there's still a lot of criticism that there's not enough methodology there in terms of how exactly that should be done. The recitals give some indications, but in terms of like what exactly you're supposed to look at and how you're supposed to measure that to get the answer, we are facing this risk. This is a serious threat or moderate threat. So I think this is something that we'll kind of have to come out along the way. But indeed, the goal or the purpose behind that is indeed to protect, to give that strengthen the protection of fundamental rights of users in the EU. And that's why there are so many references. And it's not only right to freedom of expression as a response to removals of content that is, controversial but not illegal, but also, right to access information, which is, right of everyone else, even non-users of platforms, and right to assembly. And then, of course, right to privacy and data protections, which are very strongly protected in the EU. And then they also talk about right to effective remedy with all these remedies there. So that is definitely like the underlying reason in terms of what the effect will be. And I think that especially the first round of reports and the self-assessment reports will be interesting to see, and there will be a lot of learning in the process.
It's always interesting as an American lawyer to see the different emphasis in EU fundamental rights law on the rights of listeners. We have a lot on the rights of speakers under the First Amendment, and we have some concept of there being rights of listeners to access or read information. But that right to find information and to see it is just much more emphasized in EU law in ways that I think might be useful for us to think about here.
But like on the other side, for me, and I think also other Europeans, what is interesting here is that here there's so much emphasis on the right to free speech of the platforms, right? So in the EU, or in Europe, actually, under the European Convention, that is actually still the case. The convention, the European Convention of Human Rights, these rights are not limited to individuals. Anyone's rights, so including companies, are also protected. But we don't have so many cases where, there would be a platform would rely, this is our right to free expression or to speech, and that's why we decide not to have this content there. So this argument, even though it would be valid, it's not actually that commonly used. At least that's my impression, that it's always like, right of us to speak and rights of the broad audience to access information. And the platforms, maybe right to conduct business, actually would be used more here than, this is still part of our right to free expression.
Well, that connects well to another question we have here, which is, as you know, in the US, we have these laws being litigated right now out of Texas and Florida that require platforms to carry speech they don't want to. The Florida law, for example, would require them to leave up even, hate speech or legal but horrible threats if they were posted by politicians. So I'm curious how similar requirements, maybe not specifically to the Florida law, but mandates requiring platforms to carry or reinstate content that they wanted to take down. How would those play out either under existing laws in Europe or under the DSA in particular?
Okay, so the DSA doesn't have, strictly speaking, a must carry obligation. There were some ideas like this in the negotiation process. One of them was called actually a Trump amendment, which was introduced right after Trump was deplatformed last year. And that basically required that for, content that is going to be removed, okay, you have these procedures that the DSA describes, but if that content is relevant for public interest, then there should be an extra step where a court should allow for that to happen, which created this whole, upside down kind of situation where instead of considering freedom of expression as a situation when you can speak truth to the power, that people at power actually have more protection to their speech and expression. that didn't happen. And you know, the whole discussions were actually quite ironic, because for years we've heard all these different levels in EU countries and at the EU policy makers saying, you know, platforms should act more responsibly and they should remove more and they should remove it faster. And suddenly Trump is removed. They're like, oh, no, but don't do that to us. You cannot remove content coming from a president. So that was a bit of a funny moment. That amendment did not make it to the final version, and I think everybody was quite relieved with that. There were some other ideas that would, for example, prohibit moderation content coming from established traditional media providers, basically saying, you know, they already have this independent editorial process. So if they go through that, there's no reason for a platform to then say, okay, we're going to remove your content. That also didn't make it to the final version. One of the reasons is that, you know, we see so many official sources that are still spreading illegal, or well, maybe not illegal, like, but definitely disinformation. But it might come back, because the Media Freedom Act apparently has some ideas that would be actually going in the same direction. So the DSA doesn't have that, but there are all those remedies that would basically, you know, allow for content to come back, even though the platform initially decided to remove it. And there might be situations like we had some case law in different EU countries saying, you know what, this is, you say you removed it because it's hate speech, but it's only hate speech according to your terms and conditions, and it's not precisely described, but it doesn't fall under the hate speech definition of the criminal code, so put it back. So there were decisions like this in Germany. There was also an interesting decision in Italy, which I find absolutely crazy, actually. Reinstating account of a neo-Nazi party, neo-fascist party.
That were named after Ezra Pound, right? Just
Yes,
to make things more random.
So there are options there to actually, you know, reinstate content, although not necessarily, you know, full on must carry obligation. Apart from DSA, different EU countries have introduced such ideas. So, for example, Poland is one of the countries which politicians felt that their attacks on LGBT community is often removed unfairly from online platforms, and they introduced this proposal, which would basically create like an oversight board, or another layer of appeal system, but that would be appointed by the government, and these what they call free speech council would basically make orders for the platform to put back content. Obviously, if this is appointed politically, you can imagine that all sorts of weird things happening, and only one part of or one story going back online. I think the DSA kind of froze these proposals. So I don't think we will see a comeback, at least not soon. The DSA will definitely give them enough to deal with for now. UK has, UK is now not part of the EU, so they have their own acts, and there is the UK online safety bill, which, to be honest, I'm not sure if it's still happening, partially happening. There are all sorts of different political reasons there, but there is also what they call temporary must carry obligations for content coming from established media sources. So yeah, there will be definitely some of it coming back, but not, strictly speaking, not through the DSA.
Well, thank you so much. We have more questions, but we will have to take them offline.
Thank you.
Just want to let everybody know the upcoming seminars. Next week, we will have Chris Wiffnagel from UC Berkeley, who's a great speaker, talking about counter disinformation. And then you can see on the slide here, the remaining speakers for the rest of this quarter. Thank you so much, Aleksandra.
Thank you.